Kalshi wins its biggest court battle yet as the Third Circuit rejects New Jersey. The U.S. Court of Appeals for the Third Circuit ruled 2-1 on April 6 that New Jersey's gambling regulators cannot prevent Kalshi from operating its sports prediction markets in the state. Judge David J. Porter, writing for the majority, held that the Commodity Exchange Act preempts state law when contracts trade on a CFTC-licensed designated contract market. It is the first federal appeals court to weigh in on whether prediction market platforms fall under exclusive federal jurisdiction, a question that has split district courts and triggered enforcement actions in more than a dozen states, the First Circuit Court to draw a line. Until now, the legal fight over prediction markets played out at the district level. New Jersey appealed after a lower court found Kalshi showed a likelihood of success on the merits and would suffer irreparable harm without preliminary relief. The Third Circuit agreed. The majority's logic is straightforward. Kalshi is registered with the CFTC as a designated contract market. Its sports-related event contracts are classified as swaps under the Commodity Exchange Act. The act grants the CFTC exclusive jurisdiction over swaps traded on DCMs. State gambling law cannot override that. Chief Judge Michael A. Chagares joined Porter's majority opinion. Judge Jane R. Roth dissented, writing that Kalshi's CFTC registration amounts to alchemy that transmutes its products from sports gambling to futures trading, and calling the arrangement performative sleight. Roth's dissent frames the core tension. New Jersey argued that Kalshi's offerings are functionally identical to sports betting on platforms like DraftKings and FanDuel, which states regulate as gambling. The majority disagreed, treating the CFTC license as the dividing line. Why this ruling carries weight beyond New Jersey. 3 days ago, the DOJ and CFTC sued Illinois, Arizona, and Connecticut for enforcing state gambling laws against prediction market operators. Arizona went as far as filing criminal charges against Kalshi. The Third Circuit's decision lands in the middle of that fight. The ruling does not end Kalshi's legal battles. Nevada recently banned the platform outright. Maryland issued an adverse ruling. Multiple state attorneys general have signaled they intend to keep enforcing their own gambling statutes against prediction market operators, regardless of CFTC registration. But a circuit court decision carries more authority than a district court ruling. If the Third Circuit's logic holds, Kalshi and competitors like Polymarket can argue in every pending case that the federal preemption question has already been answered at the appellate level. States would need to either convince another circuit court to disagree, creating a circuit split that the Supreme Court would likely resolve, or take the Third Circuit decision directly to the Supreme Court. The broader preemption playbook, the Trump administration's position, is not subtle. The DOJ's lead attorney in the three-state lawsuit previously represented Kalshi as outside counsel. The CFTC, under the current chair, has consistently argued that prediction markets are derivatives, not gambling, and that federal oversight preempts state regulation. For the prediction market industry, the Third Circuit ruling validates the core business model. Register with the CFTC, list contracts as swaps, and claim federal preemption against any state that objects. Whether that framework survives a Supreme Court challenge is another question entirely. The crypto connection runs through the same regulatory logic. Platforms like Crypto.com operated prediction market products targeted by state enforcement in Connecticut and Illinois. If CFTC preemption holds for prediction markets, the same argument could strengthen the case for exclusive federal jurisdiction over other digital asset derivatives. What comes next? The Third Circuit granted Kalshi temporary relief to keep operating in New Jersey while the underlying case proceeds. New Jersey can petition for en banc review by the full Third Circuit or appeal directly to the Supreme Court. Given the active circuit split, with district courts in different states reaching opposite conclusions, and the DOJ actively suing states to establish federal preemption, the Supreme Court will likely have to resolve this within the next 2 years. Bitcoin traded at $69,661 as of April 6, 2026, up 3.3% over 24 hours. ETH rose 5.1% to 2,063. The Fear and Greed Index sat at 38, still in fear territory. The prediction market ruling had no immediate effect on crypto prices, though the regulatory precedent for federal preemption over state-level enforcement could matter for digital asset classification disputes down the line.